President Emeritus. Thank you. Justice Sichale.
Thank you, Chair, and good evening, members of North Opinion. I think I hear you saying exactly what Senior Counsel Abby said, that since we now have an opportunity to develop the regulations, let's develop them to be in tandem with what the Constitution provides. And if the JS Act and the Constitution, there is a variance, or they're not speaking with one voice, then the fallback position is to go to the Constitution and not to go to the Act. I think this is done in a very useful paper that we will retire and consider it, because I believe that issues that you made before us this afternoon are indeed very useful and very persuasive. Now, I'd like to also to make one or two general comments. I think you do point out the fact that we need to define what decisional independence is. And when you look at this provision of a decisional independence, I think where it was coming from, the genesis of it was that there should be decisional independence so that judges and magistrates can make their decisions independent of any influence, independent of any fear. But over a period of time, this provision has been abused to the extent whereby you find that you can actually see corruption in some of those decisions, and judges and magistrates then take refuge under the cover of decisional independence. Now, to define it, I think might be quite difficult. And of course, we would appreciate if you as a bar can be able to assist us in defining what then amounts to decisional independence, because there is decisional independence that the law anticipated would actually serve the ends of justice, whereby judges and magistrates do their judgments, do their ruling in accordance with the law. But now, the flip side of it is that they are not now doing what was expected of them, yet they are hiding under the cover of decisional independence. Many a times, it is quite difficult to be able to pick out the corruption that is hidden in a decisional independence. But that is not to say that that is not in all the cases. In some cases, you can actually see the corruption that is hidden under that guise of decisional independence. So the thin line between where you can be able to see corruption very clearly and where you cannot be able to see corruption is sometimes blurred. And that is why, for me, I think when we say that we need to define this decisional independence, it might be quite a tall order. And of course, because we are all like the same sides of the same, two sides of the same coin, if we can help one another in really trying to see what was this decisional independence that was made to foster the dispensation of justice, and what has it subsequently mutated to become, whereby judges and magistrates are hiding under it, under the guise that you cannot interfere with them because they are rendering their decisions independently. Now, the question